Hey everyone, I want to wrap up our contracts coverage and our semester with just a brief run through of some of the PowerPoint slides that are up on Canvas. This is the same PowerPoint presentation that's been up since day one of when we started contracts in the UCC coverage. But there are a few things that I just kind of wanted to walk you through and highlight, mainly in preparation for exam 3. So you'll notice here in this little presentation, I am going to kind of skip through some slides. I do really want to kind of emphasize the material that you'll need to make sure that y'all are prepared and ready for our exam 3, which has already been posted on Canvas. Okay, so where we had left off, just to give you an idea here, so just before this slide is when we wrap up with the contract elements. And so that material took us through exam 2, I believe. And so now we're shifting, we're moving forward, kind of out of the elements, and we're looking more at the stages of contract performance, breach, and contract some other enforceability issues. Now, obviously, enforceability issues come up with the elements, right? If you are missing one of the key elements of contracts, you're not going to have a valid contract and your contract may be unenforceable. So there are enforceability issues that really do kind of come up at the formation stage. That's very, very common. You know, it's not possible to 100% perfectly separate those contract stages. But what we're turning to in this unit is kind of a grab bag of some issues that are outside of the elements themselves directly, but nevertheless, problems that can come up at different times that would affect contract enforceability, even if sort of on paper, it looks like those contract elements are there. So shifting now to just kind of a variety of enforceability problems. Most of these I'm not going to go into great detail on. There you do have some readings on this material, but I'm not going to go into this in a ton of detail at this time. One thing I did want to raise with you briefly is just it's very important to recognize that failure to read a contract is generally not going to be a defense. So even if you have a situation where you have a very long and complicated contract, even if there's a whole lot of legalese in it, the example I give a lot of the time is, when I go and renew my contract every year or every couple years or whenever it is at Verizon, right, for my cell phone. You're not handed, here's a nice big document, with all the terms laid out. You're mostly, clicking through like kind of on the electronic pad, like where you swipe your credit card, right? There's different, some of the key terms come up and you just hit next, 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 next. Next thing you know, you're signing. Well, those are contract terms. Now, most people are not going to sit there, right, and really, really carefully read all of that information. You're just going to next, next, next. Same idea with, when you get the notification, you go to a website you use frequently and they say, hey, our terms of service have changed, do you accept? And everybody hits, yeah, totally, I accept, right? Well, just because, right, you didn't, you chose not to read the contract, that's still, you are still bound by it. So that general failure to read is not going to be a defense. Oftentimes, even if there's something in there that you really weren't expecting. Now, if you have contract terms that are sort of objectively, almost really outrageously unreasonable, and if you really didn't have a very, if you really had virtually no opportunity to review the contract, prior to signing it, and that happens in some cases, those can raise unconscionability issues. So it's not to say that, in these, especially in these standard form contracts, it's not like, you can put literally anything in there that you want, right? You can't have something, for example, in your Verizon contract that says, if you, breach or try to terminate this service early, we're going to require you to pay us $1 million, right? Like Verizon can't do that. They can't do stuff that's just crazy. But unless you're able to demonstrate that there's a term in the contract that is really, pretty outrageously unreasonable, pretty crazy, you're not going to be able to raise just the pure basic, well, I didn't read or I didn't understand the contract as a defense. All right. One topic that I think for sure you'll want to have a good understanding of for at least one of your questions in exam 3 is what we call the statute of frauds. You do have some readings on this as well in Canvas, but I wanted to kind of touch on this PowerPoint and just give you a little bit of background on this. So the statute of frauds is kind of a weird term. It's not really related to fraud as in like a situation where I'm lying to you about the quality of a product or something that I'm selling you. It's really not like that kind of fraud at all. This is just the old kind of name for one original statute that was passed by Parliament back in England, back in, I want to say like the 1400s, something along those lines. It's a it's a very old rule. And what's kind of interesting about it is the modern statutes of frauds. So every single state now has rules that are similar to the original statute of frauds. And I guess what's interesting about it is they're remarkably similar, right? There really have not been a whole ton of changes in terms of the major areas that are covered by this, whether it was early common law England versus hundreds of years later now today in modern times in the United States. But what the statute of frauds does is it requires certain types of contracts to be in writing, I guess would be the shorthand that we would use for that. I'm going to go into detail about that in a second, but it requires some contracts to be in writing in order to be enforceable. So this is kind of one of those things that's outside the contract elements, right? We saw when we looked at agreement, consideration, capacity, legality, right? Just based on those pure contract elements, it would be possible to enter basically any type of an agreement and have a valid contract, even if we were just having a conversation. So the statute of frauds comes in outside of the elements. And what it says is that even if you have a conversation with someone, even if all those elements are met, your contract still may not be enforceable in certain instances if the statute of frauds applies. The idea here is for contracts that are viewed as kind of a bigger deal or more significant commitments, the courts are trying to make sure, well, that, it's legislatures who pass the laws, right? But at any rate, we want to make sure that courts have a pretty, legitimate basis for enforcing certain types of agreements. If we're going to say, yes, you are bound to this agreement, we want to make sure that we have evidence that, yes, you did commit to this, you did make a promise or you did commit to this agreement before we're going to hold you to it or ask you to pay damages or whatever it is. So to get a little bit more technical, right, other than just saying, well, contracts have to be in writing, what we really mean by that is down here, you'll see we've got this these two requirements here under the statute of frauds. And the note that if, the kind of specific language is we require contracts to be evidenced by a writing. The problem with saying, oh, contracts have to be in writing is people hear that and you tend to think, okay, we need something that's like a very official, form, or, we've got a very nice, clear, all the terms are written down. No, right? We don't want to have that misconception. That's not what the statute of frauds requires. There just has to be something in writing that gives evidence that, yes, the agreement was entered into. Something as simple as a check. Okay, if I am entering into an agreement with you, let's say that I've agreed to buy your car for $5,000. We'll see in just a second that would be a contract that's covered by the statute of frauds. It does need to be evidenced by a writing. If I write you a check and in the memo line, right, I write like buy your car or something like that. And then obviously, right, in the amount, it's going to say $5,000 and it's signed. And it's made out to your name. That check, right, if it turns out that I give you the check and you're like refusing to cash it and saying, look, I don't want to buy, or I don't want to sell you the car anymore, I've changed my mind, blah, 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 right, I would be able to use that check as evidence, right, that there is something in writing. And same, right, likewise, right, if you've got that check and I'm now trying to say, that, well, I never actually agreed to buy the car, right? Well, obviously you can turn around and say, look, you'd already made payment. So, how are you trying to get out of this contract now in a situation where, we've got this evidence that there was an agreement, you yourself, right, wrote in the memo line, like buy your car, or car sale or whatever. And so that would give you some of the evidence that you needed. Now, the other key issue with the statute of frauds is it does need to be signed by whichever party the contract is being enforced against. So in my first example, when I said, I'm trying to use the check to enforce the contract against you, that check is going to show that there is a writing. However, the problem is you haven't signed my check. So I'm actually not going to be able to, use that check as something that would satisfy the statute of frauds. I'm going to need to show that I've got either like a text from you, some kind of a memo, some kind of a letter, something that you, right, we can, there's rules on electronic signatures and whatever, right? But there needs to be something that has been signed by you, right, or the electronic equivalent of being signed by you, that gives some evidence of the agreement that I am claiming exists. Now, the check, on the other hand, right, if you're suing me for breach of contract, right, I'm the one trying to get out of the sale, you can use that check to satisfy the statute of frauds because it's a writing and I have signed it, okay? So that's what we're looking for. Don't get too caught up in, again, whether it's a fancy kind of there's fancy language. You don't even need to have all of the terms specified, as long as there's at least evidence showing some of the most essential terms. If we had a situation, in our car sale example, if one of us writes, on a Post-it note, right, car sale, Nissan Versa, $5,000, and one or both of us signs even that Post-it note, that's going to satisfy the statute of frauds, right? We're fine, right? It could be the back of a napkin, okay? Anything at all that has some evidence in writing is going to satisfy the statute of frauds. So it's pretty broad. My recommendation always is get things in writing, try to be as thorough as you possibly can, whether the statute of frauds applies or not. But if worst comes to worst, if you are in some situation, some negotiating situation where there really is a rush for time, and you just need to get something down, if the statute of frauds applies, just make sure that at a bare minimum, right, you're jotting down a few of the key terms and get the other party to sign if you want to make sure that your contract is going to be enforceable, okay? So again, not all contracts fall under the statute of frauds. There are certainly many contracts that can be entered into orally, right, or through a conversation, and it's perfectly fine. But a few of the key ones that do fall under the statute of frauds, anything involving real property. So if you are purchasing or selling like a house or land, those need to be in writing, period, in order to be enforceable. Contracts that cannot be performed within 1 year. So what we're generally looking at here is the terms of the contract itself. If you have for example, if you have a 6-month employment contract, or if you have a contract that has a 2-week deadline on it, something along those lines, for completion, those shorter term contracts, those can be entered into just through a conversation. They don't need to be in writing. However, if it's very clear, right, from the contract itself that there's no possible way for this to be performed within a year, then those contracts do need to be in writing. So again, there's kind of that long-term, short-term distinction that we make there. The final, well, there's a few others that are commonly seen in statutes of frauds, but for us, we're kind of just hitting the 3 most important for our purposes. The final one to be aware of comes from the Uniform Commercial Code. Any sale of goods over $500, right? If the UCC applies to your contract, so if you've got a contract for the sale of goods, if the price is over $500, that needs to have some evidence in writing. If it's under $500, no evidence of a writing. There have been some calls to increase that amount because that $500 amount has been exactly the same since the UCC was drafted. originally back in like the 1960s. So obviously $500 was a lot more money then than it is now. But this is just not an area where there's really been any movement in the states to change that. So in general, the $500 is the amount. 1 second. I know you like to be involved. Okay. For whatever reason, my dog has decided that he wants to be involved every time I'm doing a video. So sorry about that. Okay. So that takes us through the statute of frauds. Oh, couple quick notes on exceptions to the statute of frauds. Part performance is an exception. If you have a situation where you have a conversation, which for heaven's sakes, don't ever do this, but if you had a conversation with somebody about buying their house, and you enter into a contract, right, through that conversation, you know, that you're going to buy somebody's house for $100,000. If you pay the money and then the seller allows you to actually like move into the property and take possession of the property, you move all your stuff in, right? If the seller tries to come back and say, oh, hey, never mind, like there was never a contract or whatever, you're going to be able to use that part performance to be able to establish, look, it's very clear, right? We may not have had anything in writing, but at the same time, like the seller moved all their stuff out of the house, allowed me to move all my stuff onto the property, right? There's been delivery of the property, right? That's kind of serving the same purpose as having a writing. It's demonstrating, you know, that we have solid evidence that yes, there was an agreement there, or presumably the seller would not have moved out and allowed you to take possession. Admissions also, and usually you have some requirement that admission be made under oath, like in a deposition or in some sort of an official context. But admissions, right, that the contract was created, would say, okay, you know, even if we don't have anything in writing, look, if the other party is admitting to entering into the contract, then we'll say, okay, we'll go ahead and enforce it. Okay. The parole evidence rule. This is a rule that doesn't quite perfectly fit in almost anywhere in contracts coverage, but I raise it because it does deal with situations when contracts may be in writing. So it's in that way somewhat related to the statute of frauds, but because the parole evidence rule basically applies only when you have a written contract. And when we say that it's a rule of evidence, what this means is it's a restriction on what information you'll be allowed to introduce in court if there is a dispute over a contract. Basically, what are you allowed to tell the jury about what's in your agreement? So essentially, the issue here depends on how complete your contract is. The kind of official language for this is whether your contract is fully or partially integrated. But really all we're talking about is, when you have a written document, is it clear that it's intended to be the full agreement of the parties? We just saw in the statute of frauds, right, that you can have a very short memo on a Post-it note that would satisfy the statute of frauds and make a contract enforceable. But when you've got stuff written down on a Post-it note, it's probably pretty clear that, you know, there may be other contract terms. This is not supposed to be a complete official list of all of the aspects of the parties' agreement, right? It's just a little bit of a notation. It wouldn't be that surprising to think, okay, there may be other things that the parties had discussed that they just, you know, didn't write down because it didn't fit, right, on the Post-it note. On the other hand, right, when you go out and get a mortgage because you're going to buy a house, okay, or when you sign a lease to rent an apartment for the year, when you're looking at the extensive, you know, list of terms in a contract along those lines, that makes it more likely for us to say, yeah, it seems pretty clear that this was supposed to be the complete agreement. Now, the key with the parole evidence rule is that if you want to introduce evidence that conflicts with anything that's in a writing, So in our posted example of buying the car for $5,000, maybe you want to make the argument, oh no, really the price we had actually agreed on was $4,000. Okay, if any kinds of conversations, any kind of previous communications, if you and another party emailed back and forth a whole bunch during the negotiation process, and then you eventually signed a document that says, okay, here's the official agreement. This sets out all of our terms, and we both sign it, right? What happens if there's stuff in those previous emails that is different from what is actually listed in the agreement that you signed? No matter what kind of writing that you have, the parole evidence rule says you cannot introduce evidence that conflicts with something that is in writing in the contract. Now, hang on a second. There may be issues, right? If you can show that there was some type of fraud, if there's certain defenses in contract based on mistake, based on sometimes mutual mistake, those are other potential defenses that may come up that could change this. But if you don't have any of these other kinds of issues going on, so it's just a matter of, look, for whatever reason, we had a conversation that is different than what is listed in the contract. I then went and reviewed the contract, and this is the one that I signed. What the parole evidence rule says is you can't even tell a jury that that there were previous discussions or previous communications that are inconsistent with that contract. So if what that effectively means is, you can't raise that as any kind of a defense. You can't, argue with it. If you sign a document, that is the document those are the terms that you are bound to, period. Now, when we're talking about additional evidence, so let's say in our example of the Post-it note, let's say that all the Post-it note says is sell Nissan Versa, $5,000. There's maybe a date on it, and you both sign it. Okay. Probably there has been some conversation about when the sale is supposed to take place. So let's say that we'd agreed, you're gonna deliver the car to me 1 week from today. Well, we maybe didn't write that down on the Post-it note. Okay. Statute of fraud says that's perfectly okay. That's still an enforceable contract. Now, if we have a dispute and a breach of contract case comes up over this, because that's just what we would call a partially integrated contract, because it's very clear that contract is not supposed to be complete, I'm going to be able to tell a jury, right, and make the argument to the jury that, hey, the delivery date was 1 week. And, if I'm suing you, so let's say you're the defendant, he or she failed to deliver within that 1 week. Therefore, I'm arguing breach of contract. I can raise that additional term on the contract deadline because it's clear that's not supposed to be a complete contract. On the other hand, if you have a contract that looks like it's supposed to evidence the full agreement, you cannot introduce any additional terms that are not within the four corners of that piece of paper of your contract. So what the most important thing here on the parole evidence rule is that if you are in a situation where you are reviewing a written document and you say to yourself, gee, that does not look like what I understood that contract to be, right? This is not the agreement that I thought we had reached. You need to make sure that document is corrected before you sign anything. Now, you will have situations where whoever you're dealing with will tell you, no, don't worry about it. It's totally fine. And I know it says that, but let's not worry about it. Let's not mess with it. I know what we talked about and we're good to go and everything's fine. Don't worry about it. People will do that to you. I've been in that position multiple times. And you have to be very firm, polite, but you got to be very firm about, no, you do not ever, ever, ever sign your name on a piece of paper that does not reflect the agreement that you have, right? Make sure that all the key terms, right, anything that's important to you, make sure that is written down. And for heaven's sakes, make sure that there is nothing in that written document that is in conflict with what you think the agreement is. Because if you sign the document, that is your contract, period, from now on. You don't get to say, no, really, the agreement was something else. And like, no, really, but we had all these conversations and really what we understood was blah, blah, blah. It doesn't matter. You cannot raise that in court. So you have to be very careful about what you sign because of that. All right. Few kind of words here on contract performance and breach. Okay, back up here. Skipping down to as far as what is required for performance. Every party is entitled to complete performance. That means 100%. So whatever you were promised, you are entitled to receive 100% of that. If you buy 500 t-shirts and you receive 499 t-shirts, there has been a breach of contract. Now, that one t-shirt is not really going to be that big of a deal, but it is, you know, kind of technically, it is in a legal sense, it is a breach of contract. Jumping down here to what we call substantial performance, this is an important standard because it tells us basically how big of a deal the breach is. If in the delivery of 499 t-shirts, for example, we would say, look, the other party, right, the seller has substantially performed. That means the breach is not that big of a deal, but we still are going to say that, yes, a breach has occurred. It's just that we're going to call it a minor breach, not a material breach. We'll see in a moment, in a few slides, kind of what a little bit more on the significance of that. Okay, a few things though quickly on the standard of performance. The default rule here is that as far as whether performance is satisfactory, we look at that based on whether it would be satisfactory to a reasonable person. So there's kind of an objective standard. This would be a situation, for example, well, in the t-shirts example, right? So when we're taking a look at the quality of the shirts or things along those lines, what was were the shirts delivered on time, were the terms of the contract met. We're going to look not necessarily at am I personally happy with the performance. We would look at how a reasonable person would feel about this. Couple exceptions, if you have a very customized contract, like getting a suit tailored or something along those lines, or if you have like a portrait done, maybe something like that, something that's very personal or customized, that the standard becomes satisfactory to that particular party. Also, contract terms can get around this. So if you actually add language in that says that performance needs to be entirely satisfactory to the buyer or to the seller, that makes it personal. And so we don't have to rely on the standard of like, well, how would a reasonable person evaluate this? We're going to look at my own personal use. Time, the contract deadlines, as far as performance deadlines, this is something that's really essential to recognize, because I think it's a little bit counterintuitive. The default rule is that deadlines or delays are generally not seen as material. So if it's just a couple days here and there, right? If contract performance is due on January 10 and performance happens on January 11, most of the time the law is going to say, we're just going to treat that as a minor breach. We're going to say that there was substantial performance, not that big of a deal. The problem with that is that a lot of times, for different reasons, contract deadlines are very important to one or both parties. What you can do to get around that default rule is just add the language, time is of the essence. That is a situation, this is one of the rare cases in contract law where you actually want to be very specific and you want to use that language. Don't try to just paraphrase. These are kind of like magic words, right? Time is of the essence. Use that, and that's kind of the universal signal that deadlines are significant and that a failure to meet a deadline could be a material breach. Okay, Few words on remedies, and this is where kind of the effect of the type of breach comes into play. Damages are going to be the default remedy, right? That's your remedy at law. That's always the case. We don't get into equitable remedies unless damages are not sufficient. I'm not going to go too much into the details here on breaking down these specific types of damages. The main kind of thing to keep in mind is that our goal overall here is compensation. We want to put the party back in the position, right, our non-breaching party back in the position they would have been in had the contract been performed. So we need to basically adjust, adjust the situation and say, okay, if you had breached, here's how much value you would have received. Punitive damages, almost never available in contracts, even if there is an intentional breach. That's just an important thing to recognize. The only time you would ever maybe see that is if there's if a tort has been committed at the same time as a breach of contract. Fraud would be a good example of that. Punitives may be on the table. Otherwise, no, they're not going to be on the table. Here is where, right, moving into, let's skip that for now. Okay, moving into equitable remedies. Here is where the minor material breach thing really makes a difference. If you only have a minor breach, meaning we say that the one party has substantially performed, but it's something less than 100%. So this is our 499 t-shirts example. In that case, I was the buyer of the 500 t-shirts. I would be allowed to ask for damages in the amount of whatever the value of one t-shirt is, because I did get less than my 500. But what I cannot do is ask for what we call rescission of the contract. So I cannot say, look, I'm done, screw it all, right? I want to totally cancel the contract. I want to walk away. I want my whole purchase price back. And I'm going to give you these 409 t-shirts. I'm just going to walk out of the deal and go do the deal with somebody else. If there's been substantial performance, I cannot do that. I do not have that right. However, if we have anything less than substantial performance, meaning that we classify our breach as material, the non-breaching party has the option of either asking for damages or asking for rescission, which is total cancellation of the contract, and everybody goes back to square one. So any performance that's already been given has to be returned, and that's called restitution. So if, for example, I'm buying my 500 t-shirts example, let's say I've already paid the money. Let's say that I've paid $1,000 or whatever for 500 t-shirts. I've paid, but the deadline comes around and I don't receive any shirts, right? So total breach of the contract, zero performance. We would call that a material breach. I now have the option of saying, look, let's just cancel the contract. I'm done. I want my money back. Or I could ask for damages, and that would be another option on the table. As one example, if I had to go out, right, let's say that I am, I needed the t-shirts because I was planning to decorate them and sell them on Etsy or sell them to some, boutique store or whatever, right? If I needed those shirts in order to do something involved with my business, if I have to turn around and go out from somebody else and now get the t-shirts with a very, very quick turnaround time, and let's say that it's going to cost me $2,000 to get the t-shirts in time for what I need, I would be able to ask the original seller to pay me $1,000 in damages because I had to, I was supposed to be getting 500 t-shirts for $1,000. I had to enter into a second contract and now pay $2,000. So that difference, right, between my cover price and the original purchase price would be damages. Now I could get, because it's not a double recovery, obviously the seller has to give me back my $1,000 that I've already paid. And then on top of that, I can ask for that $1,000 in damages because I had to cover with a second seller. So my total amount that I would be able to ask for would be $2,000. Okay, quick couple words on specific performance, which is the other key equitable remedy in contracts. This is basically where instead of asking for damages, you ask for the court to require the contract to be performed. There are some restrictions on this. Specific performance is always available in real property contracts, so definitely be very, very careful when you are buying or selling a house. Make sure that you are absolutely confident that you want to buy or sell that house, because if you determine later that you want to walk away, and it's not just an issue of paying damages, you may actually be required to perform the contract if you are in breach. For goods, if contracts for goods, if the goods involved are either rare and or unique, so something that you cannot easily go out and replace on the market. Anything that's like a lot of times antique items, collectible items. A lot of times the examples that you see are like something that was owned by a famous celebrity, right? Something that you really can't just easily go out and buy on the market. If it's a Van Gogh painting, right? There's only going to be one of that particular, painting. Those examples, specific performance can be an option on the table. If you prefer to ask for damages, you can, but you have to pick one or the other. You can't get damages and specific performance. If it's a situation like the Nissan Versa sale, right? Buying a car for $5,000, obviously, not very difficult at all to go out in the market and just find some other Nissan Versa that would be roughly the equivalent. So specific performance would not be available there. For personal services, virtually never. So anything that is like an employment contract, any kind of, if you hired a landscaping company to do some work for you, any kind of a commitment that involves a personal service, specific performance is really not on the table. There have been some cases that look like specific performance when you're dealing with pro athletes, because when you signed on to one team and the athlete wants to leave, there have been cases where the courts have said, no athlete, you signed with a certain team, you need to stay with a certain team. But there's a lot of labor laws and other kinds of really specific contract issues that go into pro sports. So that's the only kind of a context I've ever really seen this come up. For the vast majority, 99% of the time, for normal contracts, you cannot get specific performance for personal services. Okay. So that walks us through our coverage, finishes up on our contracts coverage in terms of what you will need for exam 3 prep. So contact me with any additional questions now that we've kind of walked through these slides. And otherwise, good luck on your exam 3/final exam.